Mr. Lord.
Well, lady, just before the short of adjournment, we were looking at 125 of Johnson, and then at 149 of Wood. We can go to 49 of Wood, which is behind tab 42 of the authorities bundle.
Right, give me a second. So we were at which paragraph of Wood?
So Wood, tab 42, paragraph 49.
Yes, thank you.
In actual fact, it's probably helpful to look at 48 first. Because remember, Wood is a secret commission case. To ask in cases of this kind whether there is a fiduciary relationship as a precondition for civil liability in respect of bribery or secret commissions is, in my judgment, an unnecessary, elaborate and perhaps inaccurate question. The question I could consider is the altogether simpler one of whether the payee was under a duty to provide information, advice or recommendation on an impartial or disinterested basis. If the payee was under such a duty, the payment of bribes or secret commissions exposes the payer and the payee to the applicable civil remedies. No further inquiry as to the legal nature of their relationship is required. That's the law on bribes.
That's fully secret.
Fully secret. This is not to say, it's 49 now, that in the many cases in which a fiduciary relationship exists, the remedies available cannot be analysed in the terms of the consequences of a breach of fiduciary duty. If a fiduciary relationship exists, it is a breach of that duty for the fiduciary to accept a secret commission or the offer of a secret commission, and in such a case, the payer or offerer will be procuring or assisting a breach of fiduciary duty. Now, that is the bit which may well come from Herstanger, but again, there's no analysis, and of course, it's no part of the ratio or any of that kind. It's just a statement that is right, but not. It doesn't explain at all what has to be done for procuring or assisting a breach of fiduciary duty, and both will be liable to a range of remedies: accounts of profits, compensation for loss, and rescission of transactions.
It's also on the basis of a secret commission.
It is, absolutely. So all he's talking about is the liability in relation to a secret commission. Nothing at all about half-secret commissions. So if we go back to Johnson, paragraph 127, top of page 1390. Herstanger therefore seems to suggest that all that is required to establish accessory liability is to prove that the lender knew of the fiduciary relationship and paid the broker the commission in circumstances in which, as a matter of fact, there was a failure to obtain the broker's informed consent. Well, my lady, we don't really quite agree with that. And I don't want to go back over Herstanger, but as we looked at before the short adjournment, there is no analysis in Lord Justice Tuckey's judgment as to what is required to procure a breach of duty. What does the accessory have to have done? And then the reference to Wood is misplaced because Wood is just, David Richards is just talking about secret commissions. Then, going on in Johnson, paragraph 127 is where we talk about the difficulty in reconciling the approach in Herstanger with the leading authorities. Well, yes, but in our submission, it's simply a case of the authorities not being cited to Lord Justice Tuckey, and he simply doesn't go there. He doesn't address what is necessary to procure a breach of duty. But then, in the judgment, what the Court of Appeal, with the greatest respect to them, failed to do is to consider properly the two-stage test that we get from all the authorities. They failed to address that the fact-finding tribunal had not ascertained subjectively the actual state of the relevant individual's knowledge or belief, and therefore there was no basis whatsoever upon which they could be considered against the objective standards of ordinary decent people. And to pick up a point Lord Justice Snowden made, the Court of Appeal in Johnson also did not identify and failed even to consider the need to identify any natural person within the lender with the necessary or requisite dishonest mental state, which could be attributed to the lender. And the fact that that's necessary is clear from paragraph 115 of Manifest Shipping, Appeal Bundle 20, 438 to 439, and paragraph 58 of Group 7, tab 38, 840. And equally, neither did Judge Saffman consider what person. He wasn't asked to. And there wasn't any such person, as Lord Justice Snowden pointed out. Who was it who was said to be, or could be said to be, dishonest? Well, the answer is nobody, because the case of dishonesty simply wasn't being run. Now, carrying on in Johnson, when they come to the essential facts, that's in paragraph 132, applying that analysis to the particular circumstances underlying these appeals, the essential facts which make the receipt of the commission a breach of fiduciary duty are the fiduciary relationship and the payment of the commission, which puts the fiduciary in a position of conflict unless there is full disclosure and consent. There will be no breach of duty if the payment is made with the informed consent of the consumer, but informed consent is a defence to the claim for breach of fiduciary duty. Lack of consent is not an ingredient of the cause of action. As Herstang confirmed, it is incumbent on the fiduciary to establish that there was fully informed consent. But those are not the only necessary facts. The essential facts are more than knowledge of the fiduciary relationship and the payment of the commission. They would include, for example, that there was a duty to disclose the amount of the commission in the first place, and knowledge that there had been no informed consent. Namely, that the agent has not disclosed the amount and that the principal has not asked. And possibly include other matters, such as that the principal was vulnerable and unsophisticated. But how, in our case, could Engie, or anybody at Engie, be expected to know, first of all, that the broker owed a duty to disclose the amount, when the judge didn't think the broker did? Secondly, that no informed consent had been obtained, when the judge found that there had been. Thirdly, that expert tooling had not raised questions of the broker and been told what the commission was. And it was never suggested in our case that the respondent did know any of these things. And if one goes on in Johnson to paragraph 135, we are satisfied, therefore, that First Round knew that payment of a commission to the Trade Centre Wales would put the dealer in breach of fiduciary duty. Well, that can't be said and wasn't even suggested to my witnesses. And then 136. The next question is whether the consumer must also establish that the lender knew or turned a blind eye to the fact that informed consent had not been obtained, or whether, as Herstang suggests, because the receipt of the commission from the lender by the broker is on the face of it a breach of duty, fiduciary duty, it is for the lender to prove that in fact there had been no such breach because there was informed consent. As we've said, informed consent would be a defence to the claims made against the broker. For that reason, we consider the same as follow if the claim is brought against the lender as an accessory. The lender would not be able to defend the claim on the basis that he genuinely tried.
Let's just ask, I see what you say about the lack of knowledge by, in this case, Engie, in that case, the lender, of the fact that informed consent wasn't obtained. Let's put that aside for the moment. But knowledge that payment of commission would put the dealer in breach of a fiduciary duty because you know they're an agent, unless informed consent is obtained. That follows as night follows day, doesn't it?
Well, only if we knew that they owed a duty, when the judge found they didn't. How can we be dishonest? it's unsatisfactory because the way the whole case was run and it not being put. But conceptually, you have an experienced trial judge who finds, and you may decide, I urge you not to, but you may decide that he was wrong to decide. But he says there was no duty to disclose.
I think that elides the point, because the knowledge that is required for the Herstanger type of obligation is merely knowledge that the person you're paying commission to was an agent of the other side. That's all that's required, isn't it?
For a secret commission.
No, for this type of commission too. You know that they're in a breach of duty if they receive a commission without obtaining informed consent of their client. Now, the judge found no fiduciary duty here, but that's because he said there was sufficient consent. So that's circular in this particular question.
Let's leave that on one side.
Without that finding, this was undoubtedly an agent that owed a fiduciary duty and therefore would be in breach if it didn't disclose receiving a commission.
Okay. I don't put away completely my point about scope of duty.
No, I understand.
But leaving that aside, what would have to be established as an essential fact would be that Engie knew that there had been no informed consent.
Well, that's the second part of it. You were particularly pointing to the first sentence in paragraph 135. So there's no evidence, wasn't put to anyone that Engie, in this case, knew that there would be a breach of fiduciary duty by payment of commission by the lender unless informed consent was obtained.
Yes. Yeah, and so that's my first point that I fear my law's not necessarily agreeing with. But my first point is that you have to show, it has to be an essential fact, that Engie, the relevant person at Engie, knew that there was a duty to disclose. And in that respect, I ask rhetorically, how could they be? How could they have known that? It wasn't put to them, and the judge found that there was no duty. The second point is the informed consent point. As well as knowing that there was a duty to disclose, they also had to know that there was no informed consent. There's no suggestion that they knew that. It wasn't put to them, and how could they know that?
So on that part of it, this is a Court of Appeal decision, I think, saying that in this area, you don't need to find that the lender, in that case, supplier here, was aware that there was no informed consent, because the obligation lies on the lender supplier to establish there wasn't, and therefore they can't get out of this by lack of knowledge.
But proof of informed consent and knowledge that it has not been obtained are two different things. And what the Court of Appeal appear to be doing here is flipping it round and putting the burden on the supplier to prove informed consent.
Yes, that's what that's as I read 136.
But that is contrary to Group 7 and all of the authorities going back to Royal Brunei about what is required for accessory liability. I can
assume you're right about that.
Yes,
We're not bound to follow it.
Exactly. If I'm right that dishonesty is required and is required by the highest authority, then what has been said here is simply wrong.
But does that mean we don't need to follow it?
In my submission, you mustn't follow it because you've got the House of Lords and the Supreme Court, and you've got Group 7. You've got the other cases of the Court of Appeal. It is at the Court of Appeal level. If one just looks at Group 7 and Johnson, there are two contrasting decisions, but trumped in any event by the House of Lords and the Supreme Court decisions. But my lady and your lordships would have to in effect find that this is not within the normal realm of accessory liability requiring dishonesty, but it is some special liability of the kind identified by Mr. Grant that runs contrary to those authorities. But there is nothing to suggest that. All there is all my learned friend has to grapple with is Hurstanger and Lord Justice Tuckey failing to set out in his judgment what is required to procure a breach of duty, and that being picked up by the Court of Appeal in Johnson, who equally fail. Well, the one thing that can be said about the Court of Appeal in Johnson is they do attempt to set out what the essential facts are, but they can't, with the greatest respect to them, they can't be right about that if I'm right and dishonesty is required. And the authorities that say dishonesty is required are at a higher level and of the same level. Because, I mean, one comes back to the same point. If one reads the Court of Appeal at 127, they are getting very close. If not-
137?
137, sorry.
Yeah.
They're getting very close to equating accessory liability in a half-secret case with liability in a bribe case, because there is no distinction. And that can't be right, because Lord Justice Tuckey plainly thought there was a distinction. Lord Justice David Richards in Wood plainly thought there was a distinction. And they didn't think that the distinction was limited to whether or not you could get rescission as of right. They thought there was a fundamental distinction between the two. And that's where the Court of Appeal in Johnson are in danger of going wrong.
What's certainly the case is if you look at the way that the Court of Appeal in Johnson dealt with Hurstanger, I mean, they certainly are not entirely convinced by it, if I can put it that way. I mean, as I read it, if you go back to 125, after they've quoted Lord Justice Tuckey in Hurstanger at paragraph 48, which we discussed before lunch, they say Hurstanger therefore seems to suggest, I mean, they're not, that's in paragraph 125. So they start off by, you know, it seems to suggest, and then they say 127, after they themselves say, by the way, we think Hurstanger's wrong on a point, which I won't debate with you because that's relevant to another ground. But then 127, they say it's not really easy to reconcile this approach, and there were no state of knowledge cited in Hurstanger. And then when we get to 136, again, it's just as Hurstanger suggests. I mean, I think even and then 137, of course, you know, they say, you know, this appears to be consistent with the decision in Hurstanger, but just in case this is wrong. You know, so it's not an overwhelming vote of approval for Hurstanger even in this case. And they do offer an alternative rationale for their decision.
Yeah.
In case their view of Hurstanger is wrong.
Yeah. That's the blind-eyed knowledge, which is ground 8. Yeah, I mean, when one reads the Court of Appeal judgment in Johnson, I think one gets the impression that they don't even think that Johnson is a half-secret case. And they wish that they could deal with it as a fully secret case. But anyway.
But the point is, they didn't just say, okay, Hurstanger was clear on this, and this is the way we reach our decision. It's sort of, well, Hurstanger seems to support this conclusion, but in case we're wrong, here's another way of looking at it, which is, you'd say, the correct way.
Yes.
So if we're actually asking, you know, are we bound by, putting aside, you say, if you're in an accessory liability case, you're actually bound by these House of Lords and Supreme Court. It's a little equivocal, even on its terms, Johnson, isn't it?
Yes, I mean, that's absolutely right, my lord. There's two ways that they put forward. And they don't really decide which one is the right one, in my submission.
I mean, you know, they do give. I mean, they give Herstanger a lot more credibility than you would have.
Absolutely.
And a lot less than Mr. Grant would have us given, I think. But they do hedge their bets a bit, and so not entirely sure what we're bound by, frankly. If we're bound by.
Well, yeah. I mean, my answer would be you're bound by.
Yeah, I know.
Yeah, you know what my answer is.
Well, let me put the alternative view to you, which is that in the way they reached their decision by 137, which is the most difficult for you.
Yes.
First of all, they go on to deal with an alternative just in case they're wrong. So it sounds like they have made a decision that might be wrong. And then all the references to Herstanger we've just seen are sort of Herstanger supports this, and that's consistent with Herstanger. It might be so they're not relying on Herstanger to reach their own conclusion, but they're relying on the building blocks you see in paragraph 131, lifestyle equities, procuring wrongs generally, and their reasoning in 132 that because lack of consent is not an ingredient in the cause of action, it's not an element which needs to be known about by the alleged accessory. So that there's an argument, isn't there? They are making a decision of their own, even not a decision that wasn't reliant upon Herstanger, merely consistent with it.
Yes. But I mean, for example, looking at 137, my lady and your lordships will know in a halfway house case, which we must assume Johnson to be, the fact that there is no informed consent follows automatically from the finding that there was only partial disclosure. And on that analysis, the lender must be liable as an accessory for procuring the breach of duty. And they base that on Herstanger.
Well, do they? They say it's consistent.
Consistent,
It appears to be consistent with Herstanger, but they don't seem to be saying that's what Herstanger says and we're following it.
Well, and as your lordship knows, I say that is when properly analysed, Herstanger doesn't actually go so far as saying it.
Yeah.
And it's not, with the greatest respect to the court, but it's not right.
So, but if that's why I want to be absolutely clear whether we're able to distinguish it, or whether you say it's just it is what it says, and if we're bound by it, then it's determinative of our case. In which case, one's into the circumstances in which we can disregard a previous decision of this court.
Well, if it's right, and if that's really the ratio of the case and what they're saying, it is inconsistent with a whole raft of Court of Appeal authorities, including Group 7, and higher authorities. And I've given you the references to them all, because it is saying that what you don't, it is in effect saying an essential fact is not knowledge that informed consent was not obtained. They simply say if it wasn't obtained, the third party is liable, even if the third party thought it had been obtained, honestly believed it had been obtained, had good grounds for believing it had been obtained, and was the most honest man on the planet.
Yeah. The only way of explaining it, if it is the ratios to be if the ratio is to be found in 136, the first way of considering this,
Yes.
then it's not as if they weren't aware of the law which says dishonesty requires knowledge of various things, or turning a blind eye to, because they expressly go through that at 128. They know what the House of Lords, Supreme Court authorities say in this area. They seem to be creating an exception to that in this case of bribes, rather like if Herstanger is right, it said that did. Is that a case where we can say we needn't follow it because it's inconsistent with Supreme Court authority?
Well, but they don't say that they're creating this new special cause of action. They say, as your lordship points out, they say that what they're doing is relying upon all the authorities your lordship knows I rely upon, and they're looking for the essential facts. That's what they say they're doing, and they caveat the whole thing by saying if we're wrong about that, we'll look at blind eye knowledge. So it's far from clear what the ratio is. But if they say that they are following the House of Lords and Supreme Court authorities, and they're not, then in my submission, you have a position of A, inconsistent Court of Appeal authorities, in which case, my submission, you should prefer Group 7 and those cases.
Which aren't they aren't half secret commission cases.
Medstead is.
Right.
Group 7 isn't. Group 7 isn't.
No, I know Group 7, but they are accessory liability cases, and you're back to have the Court of Appeal here carved out a brand new cause of action or accessory liability peculiar only to half-secret commission cases, without saying that.
So maybe the point of departure and the point you might need to focus on to see whether this is inconsistent with any prior Supreme Court or any Supreme Court authority is 132, where the reasoning is because informed consent is part of the defence, not part of the cause of action, it's therefore incumbent on the fiduciary or the lender, as the case may be, to establish that fully informed consent was obtained. The reasoning appearing to be that in an accessory liability case, like consequential or the rest, you don't need to establish knowledge of this element because it's part of a defence to the claim, not a part of the claim. Do you follow?
I do follow, but I meet that, my lord, in the way I thought I had already, which is lack of informed consent is different from knowledge of lack of.
No, I understand why you say it's wrong. The question I'm on now is, assuming that's part of the ratio, make that assumption for the moment, then we're bound to follow it unless we can establish one of the reasons for departing from a previous decision of this court. And the only reason you presented it is because it's inconsistent with Supreme Court authority.
And because they are failing to grapple with what are the essential facts. Because in effect what the Court of Appeal are saying is it is not an essential fact that you know that there has been a lack of informed consent. They don't spell it out in those terms, but that must be what they're saying. And that can't be right and can't be consistent with all the other authorities. And it can't be a reason for the difference simply because informed consent is a defence, when one is looking at the question of knowledge and dishonesty.
I don't know, but I assume that this finding that we are debating at the moment, which is encapsulated, I think, at paragraph 173(3), which does seem to follow the Herstanger line, is something that's being appealed to the Supreme Court.
I would assume so as well.
I mean, there are some other things that are being appealed, but I assume that the commission to the Supreme Court, I mean, nobody knows. I mean, the Supreme Court hasn't said, for example, we give permission on grounds 1 and 2 but not 3. I mean, do we know, do we just know that the Supreme Court's given permission to appeal on this ground?
I don't know for sure. I would just be making an assumption.
Okay.
We can see if we can find out.
I've just checked the Supreme Court website and I can't see anything. There's no notice of appeal on it that I can see at the moment. But that's just maybe me. I've been trying to listen as well. But I mean, you're saying that that's a point which you think is live in the Supreme Court, or at least you've got no reason to believe it's not.
No, absolutely.
It's certainly 1733. Does appear to go down the Herstanger line, doesn't it?
except I say that that isn't quite the Hursthanger line, but it does.
No, I know you. I know what you say about Hursthanger, but at least appears to be. It appears if we go back to the point that I was trying to make in relation to 137, for example, and picking up Lord Justice Zacaroli's point. Although couched in this appears to be consistent with the decision in Hursthanger, they then do seem to encapsulate the first bit of 137 into their declaration of 1733, don't they?
Yeah, and I mean,
Sorry, not declaration, but conclusion.
Yeah, the conclusions.
yeah, and if push, yes, I disagree with 1733, as your ladyship and your lordships know.
No.
And in my submission, that is taking something out of Hursthanger that isn't there when properly analysed, and is tantamount to equating bribery secret commissions with half-secret commissions. And that is something that the Court of Appeal in both Hursthanger and Wood are very clearly not doing. And so, in that respect, these are, 1733 is inconsistent with Hursthanger, is inconsistent with Wood, as well as being inconsistent with all the other authorities we've been talking about.
And then just to throw further interest into the wind, the little postscript at 177 does essentially point to precisely the question we're debating, isn't it?
Yes.
Yes, so I think we've got
I think,
the measure of your dissatisfaction with the Johnson decision and the Hursthanger decision.
I mean, my lady, just as Mr. Grant was saying about Medstead, I'm not sure I quibble, just stepping back, forgetting the law and all of that, I'm not sure I quibble with the decision. One can see, as I said a few moments ago, that in a way the Court of Appeal didn't really think this was a half-secret case and thought it was a fully secret case. And, you know, there were a lot of factual differences between Johnson and our case. And we set out some of them in our supplemental skeleton. And you have, you know, the wording that's used about being deliberately misleading and all of those references. One can see that the Court of Appeal are concerned about the behaviour, not just of the broker, but also of the lender, and consider that they've got together deliberately to deceive, and they quite understandably don't want them getting away with it, and that I don't disagree with, and therefore the ultimate decision I don't disagree with. It really is just the reasoning which is contrary to all the other authorities about dishonesty, and in particular, what are the essential facts that the third party needs to know. And the Court of Appeal appear in the paragraphs we've just been looking at to say you don't need to know that there was no informed consent. The simple fact that there isn't any informed consent, whether or not you know about it, makes you dishonest. That simply can't be right. So, my lady, that's Johnson. Let me just go back to where we were in. I think we probably finished ground 5.
Yes, thank you.
So, ground 8, for which my learned friend still requires permission. And in our submissions should not be given for 3 distinct reasons. First of all, it wasn't pleaded, and would have had to be. And I took your ladyship and your lordships to the pleading this morning. The facts that are pleaded can't possibly amount to an allegation of dishonesty. And there's various authorities in the bundle. We don't need to go to them. There's Canary Riverside, referring to the House of Lords, and Three Rivers, AB.
Mr. Lord,
You have to speak
you're
up.
going to have to speak up, I'm afraid.
sorry.
If you want me to,
I'm sorry, my lord. Yeah, there's various authorities that are in the bundle that I don't think we need to go to, but just for your ladyship's note, Canary Riverside is at AB tab 31, paragraphs 14 to 18. SOFA against Swiss Independent Trustees is at AB 37, paragraphs 23 and 24. And Belmont Finance is at AB 16, page 268 of the internal reference. That's the first point, not pleaded and not put to the witnesses. Second point is, because it was not raised at trial, it cannot be raised on appeal. And we set out the authorities that I'm sure your ladyship will be aware of in footnote 33 to our skeleton. Again, it's Singh and Das, which is AB 32, paragraphs 15 to 18. Notting Hill, AB 33, paragraphs 23 to 28. And then the third reason is that
the second reason's not really a reason. You just said, the second point is, because it wasn't raised at trial, it can't be raised on appeal.
Yes.
Yeah, I mean, but that's just stating the conclusion. I mean, so why?
Well, it can't be, because it was a matter that if they wanted to pursue it, they had to pursue it at trial.
No, I mean, no. Singh and Das, Notting Hill Finance, whatever, says there is no rule that you can't raise on appeal a point which you didn't take at first instance. It depends.
Yes.
So, can you fill in the gap?
Well,
why, in this case, what factors make it unjust, inappropriate, whatever the test is, to allow them to raise for the first time on appeal a point which they didn't run at trial, any more than, I think, dishonesty was, I mean, as far as I can remember, in Johnson, it was the Court of Appeal made a finding of dishonesty for the first time.
They did.
So, okay, so there's no absolute bar.
No, there's no absolute
So
bar.
you do need to look at the, Singh and Das or Notting Hill and Sheikh approach to say, well, what makes it wrong in this case? I mean, it's not a pure point of law, which is a classic situation. You can run on appeal points you didn't run at first instance if it's a pure point of law, subject to some other safeguards about the other side having the opportunity to prepare for it, etc., etc. Where do you say you fit into the equation?
My lord, there is simply not before the court any findings as to the essential facts that Engie knew that were sufficient to amount to dishonesty. That exercise has simply not been carried out, and the relevant person within Engie has not been identified. What your lordship would need is evidence that there was a person at Engie who knew all of the essential facts and whose knowledge it is correct to impute to Engie.
That's what you would do if you were doing it from the ground up. Did the judge make findings about the knowledge of Engie?
No. Because he wasn't asked to. It's simply impossible at this stage for my lady and your lords to look at the judgment and say, well, here we are. He finds that Mr. O'Connor knew these various facts. When one considers them all, those equate with the essential facts. It would be necessary for the objective person to know and consider to be dishonest.
What you're saying is, I think, in a Singh and Das style way, is if this had been raised at first instance, the evidence would have taken a completely different turn.
As
The
I
way
said-
that the case was put and dealt with would have been different, is what you're saying.
as I said this morning, my lady, if Mr. Brown, who was then appearing, had said, crikey, I've been ambushed, we would have had a debate about dishonesty and the fact it wasn't pleaded. But let's assume that the judge said, all right, I'm going to let them run dishonesty if they want to. As I said this morning, what would then happen is the claimant would have gone away and produced a new pleading. And then there would have been evidence and there would have been questions put to our witnesses about this, about what they knew and what they didn't know, and submissions made about what was necessary for them to know. And then one comes on to the second stage of the test. Objectively, would that have been regarded as dishonest? But none of that happened.
Can you give us an illustration of a factual question as to knowledge, which you say would have been essential for
Yes.
the first instance judge to find? I mean, I'll put it that way because the way it's sometimes put in the authorities, both Singendas and Notting Hill, is can the Court of Appeal determine the point, whether it's a point of law, or in this case it would be said the objective standard of dishonesty, can the Court of Appeal determine that safely on the basis of the facts as found by the first instance judge?
Well,
So can you point to some facts which are not found by the first instance judge, which are essential to a decision of the Court of Appeal?
for example, did Engie know that there had been no disclosure by the broker of the amount of the commission? And therefore, one could carry on a breach of the brokerage agreement. Did they know that? Did you know, did Engie know whether or not Mr. Gaisley or Mr. Forster had asked what the amount of the commission was? Did they know whether or not, in response to that question, Dean Jackson had said it's X? It's a whole load of them that would have had to have been investigated, and it hasn't been. So that's why, in my submission, we are in the territory where it's simply too late now.
That's certainly right on that submission in relation to dishonesty as understood in all the authorities
Yes.
prior to this.
Yes.
But if the issue is that identified by the Court of Appeal at 1733, the ingredients in this case, by a case of half disclosure, the necessary requirements are knowledge of the existence of the fiduciary relationship and payment of commission. The latter is obvious.
Yes.
The former also is obvious in this case.
Right.
Taking away the confusion about the conflation of full disclosure with scope, leaving that aside for the moment. If all that's required is you know this is an agent who's supposed to be acting for the customer, clearly Engie knew that. Why else have all the provisions about making full disclosure?
Yes, I have to accept that, my lord, but you have taken away
No, I have taken away the key.
the response I would make, which is that Engie did not know, it wasn't put to them, did you know that Utilitywise owed a duty, a fiduciary duty, to disclose the amount of the commission? Answer, I mean, I can't speculate as to what the answer would be. I'm pretty sure I know what it
No,
would
I
be.
mean, that's not actually the question. The question is, did you know that Utilitywise was an agent? Because that brings with it, inevitably, that they have a fiduciary duty, and the question of whether they disclosed it is a defence to a breach.
It brings forward the question of, did they owe a fiduciary duty to disclose the amount of the commission?
But let's assume against you that they didn't owe a fiduciary duty to disclose the amount of the commission. What they owed was a fiduciary duty not to put themselves into a position to accept a commission which put them into a position of conflict. I know you don't agree with this, the way that it's put, but if you're wrong on your earlier grounds, the duty is not to put yourself into a position of conflict by accepting a commission unless you have the fully informed consent, and that's a defence.
I understand that, my lord. But
So all you'd need to know is you were paying a commission to somebody who's a fiduciary agent.
my lord, I don't agree with that. You would have to know that you are paying a commission to somebody who has a fiduciary duty to disclose the amount of the commission. You can't get away from that. I mean, or if one is looking at a very high level of conflict, did you know that there was a conflict? Well, the answer is, may well be, yes, we did, but we also, so did they, because the conflict was disclosed. So there can be no question whether expert tooling knew about a conflict. So one can't put it up that high. So the question is did you know that there was a duty to disclose the amount of the commission? And my answer to that, as I'm not going to keep on repeating it, is of course they didn't. But it wasn't, first of all, it wasn't put to them. And of course they wouldn't have realised that. The judge didn't even think that they did. And he sat there for 2 days. So it is important not simply to say, well, you knew that they were an agent, and that's sufficient. And that is the error that people have fallen into in interpreting Herstanger, and I don't want to revisit that, and that is potentially the error that on one reading of it, the Court of Appeal, with the greatest respect to them, have fallen into in Johnson. But it can't be, in my submission, correct. It can't be enough simply to say, you knew that they were an agent and you were paying them a commission, therefore you're liable. Absent you, who have no contact with them, in relation to a contract that has to be signed on that day because of the rates, because they're fluctuating, you are liable. In actual fact, it's more than that, you're dishonest.
I was going to say there are two elements there, aren't there? That's A, whether that conflates fully secret with half secret, and the other is whether in fact you're then only giving lip service to the requirement, if there is a requirement, of dishonesty.
Well, I don't think you're, my lady, I don't think you're giving any service whatsoever to the requirement of dishonesty. You're just throwing it out the window. And,
well, you're naming it. It is named in Johnson, for example. It's dishonesty has been conceded, etc., and then you go on to their conclusions. And
in Johnson, one can see why the court might have felt comfortable or more comfortable with going down that route, because of all the other misdemeanours that they identify, which are in our skeleton, about the lies, deliberately hiding, etc., none of which can be laid at the door of Engie. The only criticism that can be made of Engie is you didn't tell them yourself. But Engie did, first of all, impose a contractual obligation on the broker to tell them, and did put it, the possibility, I accept only the possibility, but in every single one of its contracts. Now, in my submission, that whatever definition one's adopting of dishonesty, that is not dishonest conduct. And the judge found that they weren't dishonest, albeit in relation to deliberate concealment.
So let me have one final go at this, if I may. Let's assume that the law is that an agent mustn't put himself into a position of conflict, at which he does by accepting a commission.
Payment. Yes.
And the payer of the commission knows that the person is an agent, and he knows that the terms of the commission that is being paid puts the agent into a position of conflict. Assume that dishonesty is required for liability on the part of the payer. You say, I think, that one cannot determine the question of dishonesty, which is said to be what an honest and reasonable person would do in the circumstances with the knowledge of the defendant. You know, it's an objective question, phrased something like that anyway. You say you can't answer that question of what an honest and reasonable person having the knowledge would do without knowing a further factor, and that is whether the agent had in fact sought the consent of the principal, and if so, on what term.
Yes, yes. I would say that into your lordship's basket, one has to add that the payer had contractually obliged the agent to be fully transparent about commissions and fees. The payer had put the notification on all the contracts, so had raised the possibility of the conflict. And this is perhaps the most important point, the payer did not know that the broker had breached his contractual obligations and not disclosed, and did not know that the principal had not asked, when being invited to do so, had not asked questions which Mr. O'Connor confirmed, and it is recited in the judgment, would have been answered by the broker.
So you say those are all those factors, in addition to the question of whose knowledge is, and it is relevant anyway, which individual. You'd say it's that level of granular analysis of knowledge which is essential for finding dishonesty, because without those features you can't safely determine what an honest and reasonable person in the position of the broker would have done with, because that's the test for dishonesty.
Yeah. Yes, and without that granular analysis in cross-examination of a representative, of the representative.
Yeah. Unless obviously dishonesty isn't relevant.
Yes.
But then you've lost on an earlier ground anyway.
Yes.
This is, if you win on the earlier ground, can, under ground 8, the claimants come in and say, yes, but it was dishonest anyway.
Yes.
Yeah, okay. I have it.
So, my lady, let me just check. I think we probably covered it.
I think we're going to give us 3 reasons. Not pleaded, not raised at trial, which we've been fleshing out ever since. And I think there might have been a third.
There was a third one, which we've sort of come on to, which is no realistic prospect of success.
Okay.
Because, well, for all the reasons we've been discussing. So if I can just summarise. Engie knew that the broker was ET's agent, and I accept. Engie knew that Expert Tooling had been told on the face of each of the contracts that a commission may be payable and added to the unit charge. So Engie knew that Expert Tooling was aware of the potential conflict. Engie also knew that the broker had agreed with it to act in such manner as to protect the interests of the consumer, and in dealing with potential customers to act in a fair, honest, transparent manner, and to be transparent with the potential customer in relation to all charges and commissions. And while Mr. O'Connor may not have believed that the broker would necessarily have disclosed voluntarily the amount of the commission, he believed that Utilitywise would if asked. That's what Engie knew. What Engie did not know, first of all, and I don't want to get into another debate about it, but did not know that the broker owed a duty to disclose the amount of the commission. Didn't know that. Didn't know that the broker hadn't disclosed the amount of the commission. Didn't know that Expert Tooling, who had been invited to ask any questions, had not asked about the amount of the commission. And if they had, as the judge found, it would have been told. And Engie did not know, therefore, that there had been no informed consent. Therefore, Engie cannot have known or even been suspicious that expert tooling, first of all, owed a duty to disclose, B, had not disclosed, and C, therefore was in breach of fiduciary duty. And indeed, as referred to in paragraph 95 of the judgment, at least in relation to the second and third contracts, Engie had sought and received assurances from the broker. And that's in the supplemental bundle 223 and 230.
223.
Yeah. But it's only, I mean, I stress this is only in relation, let's look at one of them. Supplemental bundle 223. Can you confirm the below has been locked in tooling? I can confirm the customer is aware that there is a fee included and we're providing the customer with energy services.
Just out of interest, but it's not relevant to 8, I think. Why did the broker volunteer that information?
I think because we asked for it.
Well, I can confirm the customer is aware there's a fee included.
Yeah.
Why did you ask for it?
Because we wanted to know.
Because you knew that without it, it would be a breach of duty.
Well, no. One's reading.
Just curious.
No, I don't know. I can't answer that. I mean, all of that could have been put to Mr. O'Connor in cross-examination. I can't answer for him.
It mirrors a point I think that's made somewhere in Johnson, but anyway, okay.
Now, just on blind eye dishonesty, can we just look at manifest shipping, which is in appeal bundle tab 20. Paras 115 to 116.
Yes, please, I would. I'm very sorry. This will teach me. I will always bring it on my laptop in future.
Oh, I see. My lady, shall I just give you the references because the
No,
other
that's fine. I'm
references
going to
are built up.
I'm going to borrow Lord Justice Snowden's. Thank you very much. And so we're at 20.
Tab 20, page 438. Now, this is in a different context. It's about whether or not the vessel was unseaworthy and whether or not the insured knew about it. 115, say that having regard to the judge's findings on causation and the insurer's concession, the suspicion or realisation of unseaworthiness had to be of both and not simply of one of the relevant aspects. One sees in the headnote what the two aspects were. There must be a suspicion of the relevant unseaworthiness and a decision not to check. Unless there is a decision not to check, not to obtain confirmation of what is suspected, there will, in my opinion, be no privity, no blind eye knowledge, however seriously negligent the failure to check. It is in this respect that, in agreement with Lord Justice Leggett, I think Mr. Justice Tuckey was in error. He made no finding of a deliberate decision not to inquire on the part of any of the individuals who, who for this purpose could constitute the assured, such a finding was, in my view, an essential condition of a conclusion of blind eye knowledge. It is not acceptable, in my opinion, to assume from the judge's conclusion of blind eye knowledge that he did find that one or other of the individuals had made a deliberate decision. So in our case, there isn't an individual to be identified, and there was nothing to put. Well, there's nothing put that could form blind eye knowledge. In summary, blind eye knowledge requires, in my opinion, a suspicion that the relevant facts do exist and a deliberate decision to avoid confirming that they exist. But a warning should be sounded. Suspicion is a word that can be used to describe a state of mind that may, at one extreme, be no more than a vague feeling of unease, and at the other extreme, reflect a firm belief in the existence of the relevant facts. In my opinion, in order for there to be blind eye knowledge, the suspicion must be firmly grounded and targeted on specific facts. And then, my lady, you can read just the rest of that. And then that's referred to in group 7, and perhaps if I just give you the reference, it's Authorities Bundle 38, and then it's pages 840 to 841 at paragraphs 59 and 60. And then in Nat West against Bilter, another case in which Lady Justice Asplin was involved, again, perhaps I'll just give you the reference. It's Authorities Bundle 40, pages 943 to 944, paragraphs 130 to 134. And as I've repeatedly said, and I apologise for repeatedly saying it, such an allegation was not put to Engie's witness. To find that Engie turned a blind eye, the court would have to have found not only that Engie knew that the brokers had a fiduciary obligation, and we've already discussed that, but also that Engie were proceeding on the unreasoned and unprincipled basis that first, the broker would act in breach of its fiduciary duties. Secondly, the broker would act in breach of its contractual obligations. And thirdly, expert tooling would not ask. None of that was put to Mr. O'Connor. And then the court would have to go on to find that Engie was dishonest. A identified person at Engie, I stress, was dishonest by the objective standards of ordinary people. But there's no factual basis even for raising that inquiry. And indeed, it wasn't raised. So, my lady, finally in relation to this, and you've seen it already, I was just going to take you to 245 and 246 of the judgment, because of course there's nothing in the judgment, particularly specifically about dishonesty, because it wasn't being pursued. In relation to the inducement of breach of contract claim, he finds 246, while I do not believe that the defendant covered itself in glory in its approach to business through TPIs, far from it, there is no evidence of dishonesty, and it cannot therefore be held to be an accessory. So, my lady, that's all I was going to say on ground 8. We move on to limitation. Ground 6. As my learned friend explained, contract 1 was entered into by expert tooling on the 29th, I think he said the 28th, I think it's the 29th of January. And it was signed by Engie on the 8th of February. And the claim form was received by the court on the 31st of March. And this is dealt with in the judgment at paragraphs 104 to 112. Our position at trial was that the cause of action accrued at the date of the contract. that was when any breach of fiduciary duty occurred, and that was when Engie became contractually bound to procure that breach. And at trial,
So when you say the breach of fiduciary duty arose when the agent committed the principal to the contract with Engie.
no, my lord, the procuring, because we're looking at the position of the supplier here. So the necessary act of procuring the breach of duty was when the supplier contractually agreed to pay the commission. That's when it was locked in. It doesn't occur.
Well, no, the supplier says, if you bring me a contract, an energy supply contract, which I enter into with your principal, then I will pay you a commission.
No, it's at the date when the supplier says, I agree to pay you a commission. And that is locked in.
What do you mean locked in?
That's locked in the moment contract number one.
Yeah, but if nothing happens, if no contract is ever brought.
No, I agree that the brokerage agreements per se do not amount to a procuring of a breach of contract, a breach of fiduciary duty.
No.
It's not the brokerage agreements I'm focusing on, it's the contracts with expert tooling. So the moment Engie agree with expert tooling, a contract is entered into and we say, we will supply you with energy at the following rates.
That's right. I say it's when you were talking about contract. I
Yeah,
think
you
for
talked
cross
about-
purposes as to which contract.
Now, I'm not talking about the brokerage agreements. I'm talking about, and we're only talking about contract number one.
Yeah.
And as I said, it wasn't argued to the contrary at trial, but this I do accept is a pure point of law, if you like, and can be raised on the appeal. If one can just look very briefly at Conway, which is in the authorities bundle tab 35, I just want to show my lady a short passage.
Which I wrote, yeah.
It's paragraph 36. It's in Your Ladyship's judgment. The promise of a payment, even if it is not eventually paid, therefore, can amount to a bribe or secret commission. And then one goes on further, it's not in dispute that the payer or promisor takes a hazardous course if he does not tell the person with whom he intends to contract about it. Only actual disclosure will do. But it's the first sentence. The promise of a payment, even if it is not eventually paid, can amount to a bribe or secret commission. And the same is said in my learned friend's book, Grant and Mumford, which is in Authorities Bundle at tab 52. At page 1429, paragraph 7058. Regardless of the proprietary liability of the agent in respect of the bribe, both the agent and the payer of the bribe are jointly and severally liable in restitution for the amount of the bribe, whether paid or it seems only promised, referring to Whaley Bridge, which, just for your ladyship's note, is in Authorities Bundle tab 5.
Hang on, wait a minute, I'm just trying to get my head around this. I mean, I understand that if a briber says to an agent, if you bring me the contract, I'll pay you X, but then actually rats on the deal, that's still capable of amounting to a bribe because it will have influenced the agent.
Yep.
But you've accepted, I think, in our earlier exchange that you're suggesting, I think, that the relevant point in time at which liability attaches is when the contract is entered into between Expert Tooling and Engie. So the fact that the commission arrangements were entered into at an earlier stage, which is what I think this is dealing with, is irrelevant. And nobody's suggesting that the commission wasn't paid.
No. No. The dispute between us is, does the liability of the accessory, in this case Engie, arise when it is contractually bound to pay the commission? Or, I think my learned friend would say, or does it only arise when the energy is supplied, so that one has energy flowing through, or does it arise only when the commission is actually paid? And in our submission, the accessory liability arises when the accessory agrees with the agent to pay the commission. And that is, your lordship's right, in one sense it arises up in the ether at the time of the brokerage agreement, but that only crystallises when there is a contract.
So there's two crystallising events here. There's an agreement to pay the commission in 2015 when the brokerage agreement's made.
Correct.
But that, you don't rely upon that. You rely upon the first crystallisation, the first contingency, which is a contract being brought. But in fact, no commission is payable under that unless and until energy is supplied under. There's no obligation, is there, on the point made to us earlier, was there's no obligation on Tooling to, as it were, take energy from Engie under that contract. It could have no. It could.
They could turn off all the machines.
Yeah. So unless why is it that it's the first contingency rather than the second?
Because, my lord, one is looking at the procuring, the dishonesty, but let's leave dishonesty out of it. We're looking at the procuring of the breach of duty. And the procuring is the entering into the contract. At that moment, assuming, as would always happen, but I accept it's still an assumption, assuming energy is used, then it is inevitable that there will be a breach of duty.
Sorry, this is why I intervened at an earlier stage. You started your submissions, and I'm just looking back at the transcript, by saying that the procuring was, which was the breach of duty, was when the supplier, Engie, agreed to pay the commission. So,
Yeah,
and you then, and I queried that, and then you say, no, it's not that. And you said it's also not the brokerage agreement between Expert Tooling and Utilitywise, and I never even thought it was that. So we're now talking about, I think your case is that the procurement, which amounts to the breach of duty, is when Expert Tooling enters into the supply contract with Engie, irrespective of whether it subsequently takes any energy.
Yes.
That's where we now are.
yes, and I'm sorry, my lord, that's where I meant to be at the beginning, because it's only...
I mean, it definitely wasn't, which
No.
is where
We are looking at the specific obligation to pay commission in relation to the site at Mercantile governed by contract number 1.
so
And that obligation, in my submission, arose
you
at the
say
date of that contract.
so you say breach of duty, procurement obligation, sorry, procurement amounting to breach of duty as and when Engie accepts the contract with Expert Tooling.
Correct. Yes.
Okay. Even before any energy is supplied, even before there's any.
Yes.
So if they had simply turned all their machines off, it's still a breach of duty.
Yes, because there is, at that moment, a contractual liability which is reflected in what will be a promise. Well, it is a promise crystallised by the brokerage agreement, but there's an obligation at that stage on Engie to pay the commission. That's the vice. So at that stage, there's nothing else. That is the vice, if it is a vice, that the accessory liability is directed at. They haven't, Engie hasn't procured the duty by supplying on the 1st of April the electricity. It's already procured the breach.
Let's just test it this way. Is there what would be the claim for compensation? Let's say on the 4th of March 2016, when no energy's been supplied and no money's been paid by way of commission. On your case, there must be a cause of action, mustn't there?
At that stage, on my case, there has been, assuming everything else against me, there has been a procuring of a breach of duty. Yes.
So you'd say liability to account, let's have an inquiry, oh, nothing.
Yeah, you get an order for an account of all sums that are payable.
And say that at that's when the first moment you'd say that there would be a cause of action capable of being pleaded by expectorate.
Yes.
Well, presumably you might say there's a remedy of rescission at that point. When Tooling finds out on the 4th of March that this contract's been procured through,
Absolutely.
you get out of it.
Yes. And rescind the contract and go with British Gas.
Well, they just not take any. They don't. Do they promise not to go anywhere else?
Well, they wouldn't be bound by any promise as long as they rescind the contract.
No. Assume the contract's in force. Are they? It's an agreement to saying we will take our energy from you.
Oh,
for the next
if
5 years.
there's no question of rescission, the first contract is for 5 years. Yes.
Yeah, so they promise not to go anywhere else.
Yes.
That's
So
right.
they do have to rescind.
Where do they promise?
Sorry.
So they do have to rescind.
But, yes. Yeah. Exactly.
Yeah.
But they could rescind.
So it locks in both parties for 5 years, not just Engie, does it?
Sorry, my lady. So as I understand it, under our terms and conditions, which I don't think are actually even in the bundle, the moment they sign the contract, we become the registered supplier, and they are obliged to take the energy from us for the period of the contract. Is that right, guys? Yeah, sorry, we become the registered supplier, actually, obviously in this case on the 1st of April on the start date, because until then the previous supplier will be providing the electricity.
Right, but then there's no provision to term just to not take energy.
No, they are
Take it from
contractually.
somebody else.
No,
They've got
as
to
far
take
as I'm aware, they are contractually bound then to take it for the 5 years.
Insofar as they want any energy.
So far as they want any at that site.
Yeah.
Yes. But perhaps a better way of looking at it is the point raised by Lord Justice Zacaroli, is that on the 1st of March, if they'd found all this out, they could have applied to rescind and said, well, hang on, we've just found out what's been going on. We're not getting our energy from you because of these breaches of fiduciary duty, and we're going to go back to British Gas. So the cause of action does accrue as at the date of the contract. And that's what the judge found. And just pick up on a couple of other points. Yes, ma'am.
But you do have the curiosity here is that the damage continues to accrue. And the damage for which compensation is sought, or whether you call it equitable compensation.
It continues on a monthly basis, yes.
yeah, I mean, every time, a unit is used, then more damage is sustained. But doesn't the fiduciary have a continuing obligation to disclose to the principal that he's in breach of his duty?
Well, what we're looking at here is
This isn't a once and for all. Sorry, what I'm really getting to is this isn't a once and for all breach, is it?
it's a once and for all procurement, is my answer, my lord. One is looking at the liability of the supplier. One is not looking at the liability of the broker.
So even though the broker would be under a continuing duty, I think, to disclose, because he's a fiduciary. I mean, I think it is established that fiduciaries have a continuing duty to disclose their wrongdoing. I mean,
Yes.
that's, I can't remember the name of it, but it's in a company director's context.
Item software, I think.
Item software and for CE, that's right, thank you. You're saying it's different for a procurer.
Yes.
Procurer is under no continuing duty once it's procured the breach.
The procurer, my lord, was never under a duty.
Yeah, that's what I'm
It's
saying.
just, it's
You're
just
saying
under a
that
liability.
The
And once
distinction is he's an accessory,
yes.
and accessories are liable once and for all when they procure, and there's no continuing breach.
Or no continuing procurement.
And presumably you would say the fact that equitable compensation, if one were to seek that against the procurer, would be clocking up over time, doesn't affect the fact that the procurement was once and for all.
No, just like when in a contractual or a tortious claim, and you have a claim for ongoing losses, loss of employment or loss of earnings, that doesn't mean that limitation for the basic cause of action keeps on starting afresh. And as far as the authorities, Grimaldi and whatever that my learned friend referred to, they are not authorities concerned with procuring a breach of duty. They are authorities in relation to either a restitutionary claim or unjust enrichment. And as we saw earlier, Lord Nichols in Royal Brunei draws the clear distinction between recipient liability, which is restitutionary, and accessory liability, which is not. And this is not, and never has been, and never could be, a claim for unjust enrichment. There can be no question that Engie didn't receive the commissions. And the other point that's made by my learned friend is, well, interest only runs from the date of payment. Yes, accept that. But that doesn't tell you when the cause of action accrued at all. It just tells you when your loss occurred, for which you are being compensated. So, my lady, in relation to ground 6, our position is that the judge was absolutely correct, and that claim is time barred. Lady, moving on to ground 7, it's alleged that the judge failed to take into account material facts in his analysis of whether the supplier had deliberately concealed material facts and whether C could, with reasonable diligence, have discovered those facts. That's a factual ground of appeal. There is quite rightly no suggestion that the judge misapplied the law. And as we saw this morning, well, Justice Snowden was rather sceptical about it when granting permission. Section 32(1)(b, set out in paragraph 113 of the judgment. There are 3 elements, all of which must be satisfied. Concealment, that concealment is deliberate, and it is something, thirdly, which the claimant could not with reasonable diligence have discovered. In our submission, the judge correctly followed the authoritative guidance granted in Potter. I won't take your ladyship to it. It's authorities bundle. In that regard, I don't know what. I haven't got the tab. It's authorities bundle tab 47. And it's paragraphs, just for your ladyship's note, 96 to 100, 104 to 105, and 106 to 109. And then as far as the judgment is concerned, he 119 of the judgment and also 126. The judge finds, in effect, that all the claimant, all expert tooling had to do was ask, and they would have been told, and therefore it could have been discovered with reasonable diligence straight away. Paragraph 123, he says, leaving aside issues, this is on deliberate, I think, leaving aside issues of whether relevant information was disclosed, where Mr. Lord asks, is there evidence of an intention to conceal facts, even if facts were not in fact disclosed? His answer, with which I agree, is that there is no such evidence. He points out that it was not even suggested in the defendant's witness, Mr. O'Connor, that there was any intentional concealment. And then on the question of concealment in paragraph 125, he says, perhaps even more fundamentally, however, is the fact that the claimant knew that commission was payable. Its case is built around the proposition that the amount of that commission should have been disclosed. The result is that in February 2016, it knew that there had been non-disclosure. In the context of a claim essentially founded on a complaint of non-disclosure, it knew of the non-disclosure in excess of 6 years before the beginning of the claim. So, my lady, then turning to the three constituents that I identified earlier, what had been concealed? Well, expert tooling was told that it was paying the commission as part of the unit rate. Secondly, it knew the length of the contracts. It knew it did not know the amount, but was happy with the price. And as far as the fact that the broker set its own commission, we've traversed that before. My answer to all that is, how is that material? As long as expert tooling are happy with the price, which they were. The price that they knew included the commission. As far as the question of it being deliberate, quite aside from what the judge says in paragraph 123 about nothing being put to the witness or anything, one has the brokerage agreements and the contractual obligations. And the points I made earlier when we were dealing with dishonesty, and I don't want to go back over them, but that as far as Engie is concerned, it didn't know. It didn't know what expert tooling had been told, had asked, and nothing was put to Mr. O'Connor about any of that. And then finally, as the judge found in paragraphs 119 and 126 of the judgment, even if there had been concealment, and even if it had been deliberate, it could have been discovered with reasonable diligence straight away. And that's paragraphs 119 and 126 of the judgment. Now, if I could just then deal with this, I think there's 2 points made in paragraph 75 of my learned friend's skeleton, core bundle, page 40. It says the supplier made a decision to disclose the possibility that the broker would be paid commission on the face of the oh sorry, he says the judge's analysis of the evidence was wrong and failed to take into account that the supplier made a decision to disclose the possibility that a broker would be paid commission on the face of the contracts. The supplier had in fact considered the extent of the disclosure that it should give to C and decided only to disclose the prospect. That is to say, implicit in the positive decision was a further decision not to disclose any other facts. Well, my lady, that's not correct. The position, as far as Engie is concerned, is that it disclosed on the face of the contracts the possibility, and it imposed a contractual obligation on the broker to be transparent about the commissions. And then the second point relied upon in paragraph 75 of my learned friend Skeleton is the point about the obligation not to disclose. And the answer to that is the answer Lord Justice Snowden raised, which is clause 8.4 about non-disclosure is expressly stated to be other than to fulfill their obligations under this agreement. So it's an obligation, yes, don't tell everybody about these contracts, other than where you have to comply with your other obligations, including your obligations to be transparent about fees and commissions. So, my lady, in relation to ground 7, it can't be and isn't said that the judge misapplied the law. And it can't be, in my submission, there's no evidence and nothing was put to the witnesses that could satisfy the requirements of dishonest concealment. And even if they could, they only had to ask, and it would, with reasonable diligence, have been discovered. So, my lady, that's all I was going to say on ground 7, and I think that wraps it up, unless there's anything else.
Thank you very much indeed, Mr. Lord. Mr. Grant.
Thank you, my lady. To address some of my learned friend's submissions in the sequence and the order they were delivered to this court. One of his consistent submissions to this court was that the judge below had made findings of fact which were findings which this court could not interfere with and which somehow precluded or otherwise inhibited the submissions that I had made and the grounds that I had put in my notice of appeal. The answer, which I think may already have come from the bench, at least provisionally, is that there were no contentious questions of fact between the parties. There was no question of whether somebody was at a meeting or otherwise, or whether somebody had said something at that meeting or otherwise. The facts were essentially agreed. The only question for the court, although there were many questions, and I don't seek to diminish the fact there were a large number of questions raised before the judge, were the application of the law to those facts and the evaluation of those facts in the light of the law. It follows from that this court is not inhibited in any way by the fact that it sits as an appellate court rather than a court of first instance, and this is not one of those cases where the demeanour of the witness in the witness box, which of course is not available to this court but was available and would have been available to the court of first instance, is of any real relevance or any significance at all to the determination of this appeal. The evidence that was given by the three witnesses is there on the page. Nobody doubted, no one said that the evidence was false or that false or mendacious evidence had been given. And the judge did not have to make findings in relation to contentious questions which were contentious as between the witnesses. So the first point I make is that this court is in no way inhibited from exercising its supervisory appellate function by any findings of fact by the judge. The second point that I wish to make, which is a point that my learned friend made on a number of occasions when he said, well, it's not said the judge failed to take into account certain material factors or did take into account irrelevant factors. I mean, my learned friend was speaking as if we were talking about the supervisory jurisdiction over a discretionary judgment or decision of a court of first instance. When it comes to evaluative questions, which are questions largely of the application of the law to the facts, it's quite irrelevant to start saying, well, did the judge take into account relevant factors or irrelevant factors? It's an evaluative question where, again, this court is in as good a position as the court below to arrive at its own conclusions. So to clear away two of the roadblocks which my learned friend sought to place before this court and before my appeal, we can get to the heart of the matter. Now, my learned friend, I think I can take his submissions on grounds 1 through to 4 in a relatively compendious way, and indeed the way he pitched his submissions made it clear that those 4 grounds were, and rightly so, were very much interconnected and couldn't necessarily be, or it would be unhelpful necessarily to look at them in strict silo terms. The consistent drumbeat, though, of his submissions in respect of grounds 1 to 4 might be encapsulated by a particular submission he made this morning, and I read it from my note. It, that is my client, should have appreciated that it was paying a commission and should have appreciated it that it was paying it as part of the unit rate which it was happy with. And he followed that submission up by saying, and the understanding of Mr. Gaisley or Mr. Forster and Mr. Gaisley that the commission that would be paid by the defendant would be paid out of its own profits rather than effectively being funded pound for pound, penny for penny by my client was, quotes, illogical. Now, I'd like to develop or dwell upon that submission, which was made on a number of occasions in various different iterations for a little while. What is absolutely clear and common ground before this court is that my client realised that the defendant would pay some form of commission to the broker. Beyond that, it knew nothing. It is said by my learned friend that my client should have, quotes, appreciated that it was paying the commission as part of the unit rate. And to fortify that submission, he kept referring to the contracts that were provided, or in fact not provided, by the defendant to my client. And he misread, if I may say so with respect, he misread the words on those contracts. And let us finally, for perhaps the final time during this hearing, go back to contract 1. They're all in the same format. Core bundle, tab 17, page 184. Where, if we again look closely, take off our glasses in my case, 2/3 of the way down the page, where it says this: renewables obligation, distribution losses, transmission losses and balancing costs are fixed and included in the unit rates. I have not the first idea what any of that means. And I wonder whether Mr. Gaisley or Mr. Forster had the first idea, even if they'd read this document, what that means. Then we have this, and that's where my learned friend's unit rate appears to come from. If you use a third-party consultant or broker to negotiate your contract, the prices quoted may include commission due to them. It does not say, although this was a foundation of my learned friend's submission on a number of occasions this morning and this afternoon, that the prices quoted in the unit rate above may include commission due to them. And as I endeavoured to show the court yesterday, if one looks at this contract in the round and turns the page to page 185, where again is replicated, the numbers might be different, but the way it's broken down is replicated, one sees all manner of types of payment or charge that are being referred to. So it is quite wrong, in my respectful submission. Putting aside, of course, the fact that we have the word may, not will, a false word, I suggest, though my clients want to know that, 2/3 of the way down the page. It is quite wrong for my learned friend to suggest that my client's quotes should have appreciated that the commission paid by the defendant would in essence be funded by them through an increment in the unit rate, i.e. the rate of 17.79 pence at the top of the page, page 184, and of course the rates differ contract for contract. And one just unpacks that submission a little further. It should have appreciated. So essentially the case that is being maintained by the supplier in this case is that there was some burden upon the claimant to engage in some investigation of its own or some process of reasoning of its own to try and wheedle out, or to use the judge's phrase, drill down into the question of how commission was paid. So essentially what is being said is that these two gentlemen, busy men working on the shop floor, making sure the factory was working, closing it up at night, making sure the machines were working away, it was up to them during those two telephone conversations, which we've looked at with some care over the course of the last 2 days, to somehow read into the garbled language of conversation 1, which we've looked at with some care, which tells you nothing at all in my respectful submission, or the entirely non-existent language of conversation 2, where all that Mr. Gaisley is told is, you do understand, or words to that effect, that we will get paid a commission by the defendant, for them to engage in some process of reasoning to say, aha, that must mean, I don't know why it must mean, but my learned friend insists that it must, that that commission will effectively be funded by us out of the commission, out of the day rate and the night rate we will be paying under the contract when it incepts.
But how do you read that sentence otherwise? I mean, it doesn't just say if you use a third-party consultant or broker to negotiate your contract, we may pay them a commission, or we will pay them a commission. So it doesn't just say that.
No, but
It says the price is quoted, and you know it's under a it's in a contractual document. It's under a line which has a day rate and a night rate.
and over the page has a number of other rates, my lord.
Yeah, okay. I can see that. Okay.
And
But it's the same.
but the,
Rate, isn't it? But anyway.
well, no, there's all sorts of there's a
Yeah,
standing charge rate.
Okay, 17.82 and the 15.59 day rate and night rate, for example, are replicated on the second page. But anyway, I mean, they're the headline rates at the top anyway. There are standing charges and bits and bobs. But how else do you sort of read that? I mean, it is saying more than just.
Well,
We'll
it's-
pay them commission.
Well, no, not will, may.
Right. Well, okay.
May pay them commission.
It's saying more than we may pay them a commission.
Well, for instance, one could go over the page and one could see the capacity market charge is £4,058.
Yeah, but okay, but it's
Perhaps there's a single, perhaps on one view, the commission that is being if may becomes will, for argument's sake, the commission is a single flat fee of £3,000, which is built into one of those figures there.
Okay, but why are we arguing this? Because, I mean, you accept this as a semi-secret commission case.
Yes, but my learned friend says that the submission that I quoted from him this morning was essentially him saying there had been fully informed consent, because my client should have appreciated X, Y, and Z, and ergo either it was out with scope on his formulation of ground one, or there was no fully informed consent. And I'm simply meeting that submission, which continued. It was suggested by my learned friend that the assumptions that Mr. Forster and Mr. Gaisley, and remember, Mr. Gaisley is really the relevant figure, and that the whole, my learned friend made no attempt to uphold the aggregation of knowledge point that had been alighted upon by the learned judge below. So we're really talking about Mr. Gaisley and Gaisley alone, because Forster was dealing with Coventry.
Right, okay, but sorry, there were 2 points. I mean, one is, which I thought you were mentioning, one is whatever the commission is that's coming out of the price you pay, it's part of the price that you pay includes a commission, however that is. And then the second question is, what's the nature of the commission? How big is it?
My lord,
there are 2 separate things.
There are the fact that I'm merely seeking to challenge a particular submission made by my learned friend it doesn't in any way follow that if my learned friend's submission on that was right, then my case fails. I'm simply seeking to challenge that particular submission. There are a whole host of other matters that are required to be disclosed, and I've sought to elaborate those in my submissions yesterday. But one of the building blocks of my learned friend's response to this appeal was the supposition that my client, and in reality it must be Mr. Gaisley, who's the poor man is there. He is. He's trying to get home. He gets a call out of the blue from Mr. Jackson. It's a 10-minute call. He puts the phone down. Doesn't think about it any further. And in fact, unbeknownst to him, literally later on that day, Mr. Jackson of Utilitywise, who's no doubt absolutely delighted that now he feels he can enter into a contract which is going to generate him a very substantial amount of commission, assuming the contract goes live. It gets to work with assiduity to sign up a contract and send it over to Engie. But looking at the position of Mr. Gaisley, for that must be the lens through which we see this, why should he have appreciated anything at all in that 10-minute phone conversation? Why should he have thought or understood when I pay, or my client or my company pays 17.79p per kilowatt hour, whenever it starts paying that, there's going to be an element of that being paid to Engie indirectly to feed and fund the broker's commission. I mean, putting aside the fact...
he'd know that if he read and understood that sentence. He wouldn't know how the commission had been arrived at, how big it was, or any of the other factors which might be relevant to how much of a
conflict
incentive to be disloyal it amounted to. But he would know, if he read and thought about it, that whatever the commission was, it was being paid for by him in the price quoted, because that's what it says, isn't it?
Well, my lord,
I'm not saying it's fatal to you that
No,
that's
I quite understand.
I'm just wondering why you're beating that drum so assiduously.
Well, it may be an experience, my lord. I'm simply alighting upon particular submissions made by my learned friend, which I respectfully challenge. And that fed into a wider submission, which again was the subject of consistent reiteration by my learned friend, which is that all that mattered when it came to fully informed consent was whether or not my client was that apparently my client was happy with the bottom line. All my client apparently cared about was the number it was paying. And if it was happy with that number, it didn't need to worry itself whatsoever about the constituent elements of that number. Now, that was a very big submission. And it's a substantial submission because if it's correct, it would dislodge a large part of the jurisprudence surrounding bribery that has developed over the last few decades and possibly centuries. Because essentially, it's the same submission made by Sir Edward Marshall Hall, Queen's Counsel in Hovenden, where he argued on behalf of the respondent alleged briber, as the court may recall, that the jury below had not held that the £28,000 that was paid for the cigarettes over the relevant period by the plaintiff appellant was in any way an overprice. So no doubt it could have been said by Sir Edward in that case, well, the plaintiffs were happy with the underlying price they were paying for the cigarettes. Why are they quibbling? They knew they were paying £28,000 for the over time. They knew what the cigarettes were that they were buying, so they have no complaint. But no, the answer in Hovenden was no. That is not the answer. The answer is that there is irrebuttably presumed to be, to use the language of Lord Justice Collins in Grant and Gold Exploration, a superplus, i.e. that you have irrebuttably paid additional to the amount you should have paid as the plaintiff the plaintiff principal, the amount of the bribe. So it is no answer to say, as my learned friend insisted upon, all they were concerned about was the bottom line price. And one can test that proposition in this way. Let us say, contrary to the judge's decision and my learned friend's submission, that Mr. Jackson had said to Mr. Gaisley, which apparently is entirely immaterial to Mr. Gaisley, he didn't need to know about it. I should say to you, Mr. Gaisley, that my client Utilitywise, or my employer Utilitywise, will simply choose whatever commission it sees fit, by reference to no standard guidelines, by reference to no objective criteria, just whatever it chooses to make. Am I feeling greedy today? Am I feeling moderate? Which will be added penny for penny to your commission, to your underlying rate. So that, let's assume the conversation. So Mr. Jackson says to Mr. Gaisley.
Grant, is this truly reply? I think we have the point that you're making in relation to Mr. Lord's submission, and you want to point out that is, you would say, incorrect. But I'm a little bit concerned that we're going a bit further and we're making further submissions in the vein of ones which have already been made.
The submission I was seeking to make was in answer to a submission made by my learned friend, which is that the principal did not need to know the mechanism or fact or amount, the mechanism or amount of the commission. When I say mechanism, I mean the means by which it was generated and the fact that it was entirely at the whim of the agent. And I'm seeking to test that submission by saying I would have thought it was obvious that Mr. Gaisley, if he was told, well, I could go for 1p or I could go for 5.6p, Mr. Gaisley, that Mr. Gaisley might have responded by saying, well, I prefer you to go for 1p rather than 5.6p. And if you refuse, I might actually withhold my custom and go to another agent who's willing to be a bit more reasonable. Now, on that, I'm sorry if that's trespass onto matters that don't arise strictly by way of reply, but it strikes me that that is a perfectly clear test of why it is quite obvious that the mechanism and amount of the commission was something that my client had the closest and most material interest in knowing, and it is a false submission or a wrong submission for my learned friend to say that all they needed to know about, all they cared about, was the bottom line. A matter for the court, of course, and I'll say I won't trespass any further on the patience of the court by persisting in that or adding to that submission. It was then said, and I quote again from my note, from my learned friend's submission, a principal cannot deny knowledge if he did not understand it or had an illogical assumption about it. Well, I don't see how Mr. Gaisley's assumption could be possibly described as illogical. And it strikes me that if he misunderstood the position as he plainly did, he can't be blamed himself. The blame for any misunderstanding must surely rest with the fiduciary, whose duty it is to give absolute clarity to his or her principal, to ensure that they are not only given full information about the nature and extent of the conflict, but that they have given fully informed consent to that conflict as so disclosed.
Was it not accepted by the witness that it would be illogical, and is that not recorded in the judgment?
Well, my lady, the witness was pressed on various matters, and his Mr. Lord said, well, is it illogical? And he eventually said, well, I suppose it is illogical. I mean,
He being Forster.
Mr.
Yeah, it's paragraph 17, I think.
Mr. Gaisley.
Mr. Forster, exactly right, not Gaisley, Mr. Forster. But why is it illogical? And I ask that question because we're assisted on that question. We're assisted in the answer by going to answers given by the defendant itself when it was being pressed 2 years after the event to be more clear about the nature and fact of the commission. So that if we turn very briefly to page 266 of the supplemental bundle, I showed you this very briefly yesterday afternoon. We see this is an answer to a gentleman at Expert Tooling seeking answers to various questions. This is tab 43 of the bundle. We see Ms. Carter of the complaints team of Engie, instead of saying, well, it's perfectly obvious, no one could think anything other than commission takes one form and one form alone, which is it just gets added to your day rate or night rate. No, she, on behalf of my learned friend's client, says this commission can take various guises. So why is it illogical, given that it seems to be entirely logical to Ms. Carter, that the commission can take various guises? Why is it illogical for Mr. Forster, whose knowledge in any event is irrelevant, to think, well, the money might be paid out of the defendant's commission, out of the defendant's own pot?
I'm sorry to interrupt you, but I don't understand where you're going with this, because that was what the witness said, and that is what is recorded by the judge. I can quite see that what Mr. Lord makes of it may be something that you take issue with, but you seem to be trying to go behind what was the evidence.
Well, my lady, with respect, no. The fact that a gentleman might say, whose knowledge is in any event irrelevant, might say, being pressed in cross-examination, I accept it's illogical, does not prevent me saying, in fact, because it's a evaluative question, it's not a question of fact. Obviously, if he said I was in Manchester on that day, I couldn't stand up and say he wasn't. He was an idiot. Why did he say that?
It's not Mr. Forster in any event, and you're saying overall, taken in context, it wasn't illogical.
Quite. I'll say no more. I've pressed the call. I pressed the point.
I follow.
Sufficiently. If I can come on to ground 5 for a second. Now, one of the submissions I made yesterday, which was founded upon a number of prior submissions that I had made about the common parentage of secret commissions and half-secret commissions, was to suggest that the law in this area should be rational and should offer rational outcomes depending on different factual scenarios. And one of the submissions I made was to postulate what I described as scenario 1, which was that the principal has a relationship with the agent and the third party makes a payment to the agent, which it says nothing about, or a limited amount directly to the principal with whom it is to contract. And that if the agent chooses, for whatever reason, to say nothing, that creates a strict liability on the part of the third party. Whereas if entirely fortuitously and extraneously to decision making by the third party, the agent chooses to, whether intentionally or unintentionally or what have you, to make some veiled allusion to the fact that commission is to be paid by the third party to the agent. On my learned friend's analysis, that converts what is a strict liability. When I say strict liability, i.e. a liability which is solely founded upon knowledge of the agency and payment of the commission, and that's the Hovenden or the Mahesen liability. On my learned friend's analysis, by reason of that purely fortuitous fact, or what may be a purely fortuitous fact, the liability of the third party is by some strange legal alchemy converted into a dishonesty-based liability for accessory or an accessory and dishonesty-based liability for procurement or for of a breach of fiduciary duty. And my suggestion to the court was that that is an entirely illogical outcome and not an outcome which this court should countenance. And I was expecting and waiting for an answer to that point. Answer came there none from my learned friend. And the reason that there was no answer is no fault of his own, of course, but because I suggest there is no answer to that proposition. And I suggest that proposition takes us to a proper understanding of Herstanger, where essentially what Lord Justice Tuckey, agreed in by Lord Justices Jacob and Waller, is saying is, yes, he's using the envelope of equity as opposed to common law, but he is recognizing that in terms of the actual constituent aspects of the fault, using that term in the broadest sense, the constituent aspects of liability for procuration of a breach of fiduciary duty, that being the label he uses, is essentially, or in fact not just essentially, in fact precisely the same as the constituent aspects, the constituent elements for a liability in bribery. I'm not going to go back to Herstanger. This court has looked at it with minute attention, of course, but it is absolutely clear, in my respectful submission, that that Herstanger establishes that the third party in a, quotes, half-secret case will be liable, putting aside the remedial response, let's put that to one side for the time being, will be liable when there is proof of precisely the same facts that are required for proof of liability at law in bribery. And we know that the liability of the briber at common law is founded on two facts. One, knowledge of the agency. Two, payment of the commission to the agent.
And so is it a primary
Yes.
liability? That is what you're saying?
Yes.
The references to accessory liability at 34 or so in Herstanger are just verbiage.
Well, they are then replaced with references to procuration in,
When it comes further down.
39.
So procuration is what Lord Justice Tuckey was at, and that's in 38 and following.
That's right, exactly.
And
right.
it's a primary liability.
It's a primary liability. Now, I should say that if I'm wrong on that it's an accessory liability, it doesn't mean that my case falls apart. My case is to say, my facts are precisely within the four walls of Herstanger. I didn't understand my learned friend's submission that somehow I was trying to recast a cause of action that differed from Herstanger. My skeleton argument, I thought, was pellucidly clear on the question that we said that the simple application of Herstanger gives an absolute and clear answer to this case, which is an answer in my favour. There are no material distinctions between my case and Herstanger. I suggest that Herstanger is properly conceived of as a primary liability. The reason I say that is because on analysis, a half-secret commission and a commission and a fully secret commission have a common parentage. The reason the law sets its face against both secret commissions and half-secret commissions is precisely the same, i.e. the risk of subordination, i.e. the risk identified by Lord Reed in Privinvest, the risk of creating a conflict between duty and interest. That arises whether it's secret or half secret. And that is why Lord Justice Tuckey in Herstanger said in unequivocal terms that the constituent elements for liability in a half secret case are the same as they are in a bribery case, a fully secret case, although he used the language of equity rather than law. But as a matter of what needed to be proven, they are the same. And I go on to say that if one looks at Johnson, which looked at Herstanger with great detail, which looked at all the dishonesty cases as well, they arrived at precisely the same conclusion. Paras 137 and 1733, plus a bunch of other paragraphs, but those are the clearest articulation of the outcome. And as the court, I think, observed this morning, if one looks at 137 and 1733, it is saying with absolute precision that the constituent elements for liability in that case are the same as the constituent elements as identified by Lord Justice Tuckey in Herstanger, and they are the same as the constituent elements identified in the bribery cases such as Hovenden and Mahesen. And that is quite entirely right in my respectful submission, given that in a half-secret case, there has definitionally not been fully informed consent to authorise and ratify the breach of fiduciary duty. And that is why, if we pick up again, if I may, bundle 1 of the Joint Authorities bundle and go back to tab 9, the decision, I'm so sorry, tab 7, the decision in Hovenden, and go back, this is page 136 of the external pagination, and go back to the highly influential decision and judgment of Lord Justice Roma in that case, when he comes to define what is a bribe, this is in the second column of the page, roughly 2/3 of the way down the page. And if I may pick it up here, if I may say that the following is one statement of what constitutes a bribe. If a gift be made to a confidential agent,
I can't find where you are.
what, page 136 of the external pagination, my lord.
Sorry.
Tab 7,
Yes.
Yeah.
second column, my lord. Does your lordship see Roma LJ 4 lines down?
Got you. Yeah.
Thank you.
There
No,
we
no,
go.
not at all. I'm going quickly. I accept. And if we go about 10 lines down from the top of the page, we will see the words starting without attempting an exhaustive definition. I may say that the following is one statement of what constitutes a bribe. If a gift be made to a confidential agent with the view of inducing the agent to act in favour of the donor in relation to transactions between the donor and the agent's principal, pausing there, of course, that's the subject of an irrebuttable presumption, as the law as it's now stated, and that gift is secret as between the donor, i.e. the third party, and the agent. And then this, that is to say, without the knowledge and consent of the principal. Now, knowledge and consent of the principal. Precisely the same language had been used by the Master Rolls in Dun and English 28 years earlier in the breach of fiduciary duty case. And of course, we've seen the concept of fully informed consent is a dual concept of knowledge and consent. These are not two separate legal streams that are flowing in parallel without being, so to speak, fed by the other. We are talking about a single fundamental conception of a payment to an agent in circumstances where the principal has not knowledge of the payment and has not consented to that payment. And whether you conceive that in common law and in equity, the underlying principles are the same. What distinguishes the half-secret case from the secret case is the remedial response of the law in the half-secret scenario, which I've spent much time on yesterday, and I will not trouble the court with any further on. But the essential foundation of liability is the same, and rightly the same, because in both cases there is not knowledge or consent unless the payer of the bribe can prove, the burden being upon it, that there has been knowledge and consent. So let us clear away the notion, adumbrated by my learned friend, that there is some special discrete area of law that applies to half-secret cases that is somehow siloed off from the larger and wider law of bribery. And let us also consider, my lady, the propositions my learned friend made as regards the importance or apparent essentiality of dishonesty. He started with Royal Brunei and Tan. And I'd just like to recall to the court that decision. It's in bundle 1. If you have and it's tab 13. And if we go back to a page that my learned friend particularly alighted upon, which was page 224 of the external pagination, where Lord Nichols referred to the distinction between the foundations of liability, between an accessorial liability and a receipt-based liability. And he said that, and this is I'm so sorry, I should have given you the precise reference, this is a F on the page, external page 224. He said that different considerations apply and recipient liability is restitution based. Now, my claim, as pleaded, and with the imprimatur of Lord Justice Tuckey in Herstanger, is in essence a restitutionary claim. And I can point, I don't need to point any further than my particulars of claim, which seek, whether as money hadn't received or as equitable compensation, we keep our options open within the pleading. Paras 24, 25 and the prayer, we seek plainly and unequivocally the payment by the defendant of the amount of the bribe of the commission that it has paid to Utilitywise, the broker. Now, that at common law.
But equity regards procuring as a species of accessory liability. I mean, that's what Lord Justice Tuckey was talking about.
Well, what Lord Justice Tuckey is emphatic about is that the liability that he is the Court of Appeal is recognised in Herstanger is not a dishonesty-based liability. He gives the remedy, having eschewed any suggestion that Herstanger, on the facts of that case, could be described as dishonest, but he gives the remedy.
He doesn't discuss dishonesty as well at all. So I think what you just said puts it too high.
Well, with respect, if one looks back, I'll make the submission. Your Ladyship will make of it what your Ladyship will. But if you look at paragraph 38 and 39, he says, in a case such as this, I acquit Herstanger of any finding of fraud. Would it assist if I just go back there very briefly? No. There's an express acquittal of any suggestion of dishonesty, or I think he uses precisely the word fraud, at paragraph 39. It would be unfair to visit the agent and any third party involved, i.e. Herstanger, with a finding of fraud.
But that's not what's being talked about there, is it? I've understood that to mean where one is looking at a half-secret case rather than a fully secret case, it's unfair to visit upon the agent or the third party a finding of fraud, and therefore I'm looking for a different umbrella.
Yeah, but what
that's how I've understood it.
What flows from that is that the Herstanger liability which is no more than what I'm seeking to advance before this court, and whether it's treated as a primary liability or a secondary liability is in one sense irrelevant, but I'm seeking to assist the court in trying to suggest what I say it should be. Herstanger liability is explicitly and expressly not dishonesty based, and Johnson so found as well, see paragraph 125, and Johnson actually arrived at if you go back to paragraph 173, little 3, a decision that the liability that it was recognising was a liability which involved proof of the matters set out at 1733, which are no more and no less than the matters found to be required to be proved in Herstanger, and no more and no less than the matters that were proved in this case, and which should have led to a to judgment in my client's favour. But may I just delay the court? I'm conscious of the time. May I just delay the court for 2 minutes on that paragraph of Brunei and Tan, where the distinction is made between recipient liability and restitution liability. In reality, the liability being sued upon in this case is a restitution, is a receipt based liability, and therefore it's a restitutionary claim, because, as was discussed at some length yesterday, the bribe or the commission that is paid by the third party, whether it's in a semi-secret, a half-secret case or a fully secret case, is subject to a claim in money hadn't received or the equitable simulacrum thereof, because of the law's irrebuttable presumption that the contract price has been swollen to the amount of the bribe. Hence the outcome in Hovenden and the rationalisation of the outcome in Hovenden, where it is said, regardless of whether the figure of £28,000 was the right price to pay on the market, it is irrebuttably presumed that the price of £28,000 paid has been swollen by the amount of the commission, which was £700. Ergo, there is a liability, in the words of A.L. Smith, L.J., on the part of the payer, let's forget about the agent, on the part of the payer to disgorge that amount. What was the claim I was bringing in this case, or my client was bringing in this case? It was a claim seeking to require the defendant to disgorge the amount of the bribe, which is irrebuttably presumed to have inflated pro tanto the amount of the payment under the supply contract. So, and in fact, as my Lord Justice Snowden put it, in fact, we don't need to rely even on presumptions here, because we know for a fact that every time my client paid £100 under contract one to my client, my learned friend's client, 39% of it, or whatever it might be, an extraordinary percentage, one might think, was, I'm so sorry, my Lord.
Has a knowing receipt claim just drifted into this case at 4:15 on the second afternoon?
The claim that has been...
What are you saying? I'm just struggling to understand exactly what you're saying.
We are bringing a claim for payment to us of the actual amount of the bribe that was of the commission that was paid by Engie to the third to the agent. We have always maintained that this is just as is said at paragraph 48 of Herstanger, that this is a quasi-restitutionary claim. We're not seeking to prove loss. We are seeking disgorgement of the sum paid by the defendant. I am simply seeking, by reference to Tan, to show why properly. I'm not saying I'm not interested in whether it's a claim under in knowing receipt. That's not my claim. I'm simply seeking to show that this is essentially to call it an accessorial claim liability, and therefore to say therefore it must perforce be informed by dishonesty conceptions, is to misunderstand the actual nature of the activity on the part of the defendant and the nature of the remedy being sought by the claimant, which is not loss-based.
Well, if that's right, if you go to TAN, we're in TAN, are we? At page 222. This is Lord Nichols.
Yes.
At D, he defines what the issue is. Whether the breach of trust, which is a prerequisite to accessory liability, must itself be a dishonest and fraudulent breach of trust by the trustee. So it was actually, the question was actually to do with, can you be liable as an accessory if you've been dishonest but the trustee hasn't been? Right?
Yes.
And then there's a paragraph which follows, it must be noted. And as I read that paragraph, I'll give you a moment to read it, but it's dealing with accessory liability. I mean, it says so right in the middle of it.
Absolutely right.
And then he says, the position would be the same if, instead of procuring the breach, the third party dishonestly assisted in the breach. But he's treating a procurement of a breach of fiduciary duty by a trustee as a species of accessory liability, isn't it? Are you saying that's wrong?
No, I'm not saying that wrong.
In which case, I'm sort of struggling to understand.
No, but what I'm trying to explain is that the nature of the liability being sued upon in this case, as per Herstanger, is a liability not for loss caused by the assistance in the breach of fiduciary duty. It's for the actual receipt, presumed receipt, via the presumptions I've referred to, by the third party of a sum of money whereby the payments I have made, my client has made over time under the energy contract are swollen and deemed swollen by the amount of the bribe.
And so, Mr. Grant, as I mentioned earlier and asked you, you are saying, in fact, let's put aside all this accessory stuff. Let's put aside all these interesting cases. Our claim was based on Herstanger, and Herstanger says, in fact, but for the slight wrinkle in the remedies, the position is the same, whether it's a bribe in the sense of fully secret or it's half secret. And accordingly, what we're looking at is, in effect, money mirror image of money had and received, and it's a primary liability. End of story. Don't care about the rest.
Whether it's primary or accessorial is it shouldn't matter to the out to.
I think you said earlier it was primary, but never mind.
I'm so sorry.
But you're saying don't care about all the rest. Irrelevant. That's it. Cut and dried.
Well, I hope my submission isn't quite. I mean, maybe quite as narrow as that. But I say that. I hope I have some support in saying, by reference to paragraph 137 and 173 of Johnson, that where if they are right, then I must succeed. If those paragraphs are right, I must succeed. As my learned friend said, putting aside the doctrine of precedent, that they were in some way wrong. And why? I'm conscious of the time, so there's no way I'm going to go any more than another 5 minutes, because I've trespassed on the court's patience sufficiently as it is, and I'm grateful for the extra half hour that you granted me this morning. Can I need to just spend 3 minutes each on ground 8 and ground 6 and 7.
But please do so by way of reply rather than reiteration.
Quite. Yes, I will. As regards ground 8, the findings of the judge are entirely sufficient for my purposes. It's not a question of, we need to extract further findings and we can't do so, and the judge didn't make a finding on relevant fact A or B so as to deny me success on ground 8. In our supplemental skeleton argument, we have identified precisely the facts found by the judge, which yield and can only yield one answer, which is liability if it's dishonesty based, then a dishonesty based liability. The fact is, Mr. O'Connor was put up by the defendant as the person who knew about the relationship with Utilitywise. He was in charge of it.
He wasn't the person who seemingly agreed, if agreement it was, the contract, the contract in question. That was a lady called Rebecca
Major. Rebecca Major, without any disrespect to her, I suspect is one of a large number of individuals at Engie who had a particular role to play and received an email and then computed the email into a quotation and then sent it back again. Her mental state is entirely irrelevant to the question.
We don't know that. We have no basis on
her
which to assume
mental
that.
state is entirely irrelevant
But
to
you
the
would have
question of
needed,
her honesty, the question of the company's honesty.
But this is the point. If dishonesty is a necessary component element of the claim that you make, because that's the hypothesis we're dealing with at
Yes.
round 8.
Yes.
You would have had to have identified in your pleading, would you not, as an essential well, just hear me out on it. You are supposed normally to plead all the essential elements of your cause of action in your pleading, and if dishonesty is an essential element of your cause of action, you would ordinarily, I think, need either in your pleading or in a response to a request for further information to identify the person whose state of knowledge is to be attributed to the company in the first stage of the Ivy and Genting inquiry, and to state the basis on which their knowledge is to be attributed for this purpose to the company. And then there would be a second stage where the court would say, is objectively that what was done on the basis of that knowledge dishonest or not?
My lord, the position I say is very simple indeed. Mr. O'Connor, there's no suggestion that Mr. O'Connor's knowledge should not be attributed to the company. He was the only witness who was called. He spoke to a whole raft of matters on behalf of the company. He conceded a number, and there were findings to this effect, a number of facts. And the facts that he conceded or admitted were 3 in number. 1, I knew there was an agency, a relationship between the principal and Utilitywise. 2, I knew that we were paying a commission which had the following constituent facts. 3, I knew there was a conflict of interest between Utilitywise and the claimant. Whether that's a necessary finding is open to question, but nonetheless it was found and it's in my favour. And 4, I knew, and again this is not necessary to a finding of dishonesty, but nonetheless I make reference to it. 4, I knew, as recorded by the judgment, that it was that the broker would not speak about the fact and content of the commission. Those are 4.
Unless asked.
Unless asked.
And then, if asked, he would. I think his evidence was he would have
Expected to be
the
honest.
broker to
give an honest
say what the
answer.
arrangement was.
Now, those 4 findings, which are findings about the knowledge of the company, are entirely sufficient, by reference to the analysis in Johnson, to justify a finding in dishonesty under the objective 2nd stage. End of story.
On these transactions.
Absolutely.
How did he know that the broker hadn't made the disclosure when asked?
Well, that presupposes exceptions of my learned friend's submission, that in order to, that my learned friend effectively said, in order to ground liability in a case such as this, it would have to be proven that the energy supplier knew that the broker had not disclosed material matters about the commission to its principal. Now, I dispute that is a necessary finding to a finding of dishonesty, and I pray and aid Johnson to that effect, which made no such finding. In fact, set out what needs to be proven for there to be dishonesty. I dispute the proposition that in order to establish, assuming that it has to be established, dishonesty on the part of an energy supplier, whether it's this company or any other, that it would have to be proven that the company positively knew in respect of any given transaction that the broker had not disclosed, given full disclosure of the question of commission and the material matters relating to the commission to the principal. And again, in the 2 minutes I'm going to spend until I'm going to sit down, unless my lord, my lady wants to carry on, just remember 2 decisions in the law of bribery, both of which have been influential. The first is the decision of Lord Justice Collins in Grant and Gold Exploration, where I think it's page 249 of the judgment, it's in the court's bundle of authorities, where the judge says, and it's repeated, I think it's repeated by my lady in Conway, if the third party takes the, quote, hazardous course of leaving the question of disclosure to the broker, then it must take the consequences. And the second decision, the decision of Mr. Justice Havers in Taylor, the decision from the 19th, Taylor and Walker, tab 12 of the court's bundle. I don't take the court to it, but page 205 of the internal pagination of the, sorry, I think it's the external pagination, where Mr. Justice Havers, in that case, the agent had assured the principal that it had given disclosure of the commission to the agent, to the principal. It had assured the third party, I should say, that it had given disclosure to the principal of the fact of the commission. And his lordship in that case said it did not matter because it's part of the hazardous course. And I say that the defendant in this case cannot cannot properly defend this claim by saying, well, I assumed that if the question was asked, then the broker would have given an honest answer, because it has taken the hazardous course. Can I make one further submission about ground 6, which is that my lady said, well, on the 9th of February, i.e. the day after the contract was entered into, the claimant could have sought rescission of the contract. It didn't need to wait till the 1st of April to seek rescission, and therefore it had some sort of cause of action on the 9th of February. Now, there are two answers to that point. Answer 1 is it's not apparent that the contract imposed any obligations whatsoever on my client. My learned friend made some submissions by reference to some terms and conditions that are not before the court. So there is no, on the face of it, there's no need to seek rescission at all. Just don't take up the contract. There's no minimum obligation on the part of my client to buy over a 5-year period a particular amount of electricity. But the second answer to that point is found in Lord Legate's decision in BOS and Smith, where the question of accrual of the cause of action is ultimately based upon the nature of the remedy sought. And what Lord Legate says is you start from the remedy. What is being sought by the claimant via its claim? And then you ask, when did all the facts come into life that allowed the claimant to seek that remedy? That's the moment when the cause of action accrues. What is my cause of action here? I'm not seeking rescission. I'm not interested in rescission. I'm seeking payment of the bribe, the commission that was paid by the defendant to the broker. Now, there was no commission paid by the defendant to the broker.
Actually, you're not. You sought compensation and all necessary accounts, inquiries and orders, and an order for payment of all monies found to be due on the taking of accounts.
Well, that wasn't pressed. What was sought at trial was...
I've read out pretty much the entirety of the only press relief that are left once you are not pursuing your payment for money hadn't received or interest.
Equitable compensation in an amount equal to the commissions paid by the defendant to Utilitywise.
Compensation.
I could not bring that claim. What could I have? On the 9th of February, the day after the contract was entered into, was signed by Engie, how could I have brought that claim? It had been struck out.
Okay. So, in fact, what you're saying, is this right? You're saying, is this a continuing breach of some, or is it a continuing breach in some way?
Well, there are two ways of putting it. I think we discussed it yesterday, and my lord made some illuminating, if I may respectfully say, some comments on that, which is that either one talks of the claim as being a disgorgement simply of the bribe as paid initially on the 30th of June in respect of contract 1, the payment on account, or one looks at it in terms of every time a payment is made under the contract, which necessarily happens after the 1st of April, because there's no consumption before the 1st of April, then an aspect of the sum of money that is paid over. This feeds the restitutionary nature of the claim, has superadded within it the commission, which is, so every 17.8p I pay over, 5.6p of that has been increased by is commission to be paid indirectly to the agent. I couldn't have brought that claim on the 9th of February. I had the claim that the obligation to pay commission is consumption based. If there is no consumption, there is no obligation to pay commission. And that is should be the end of the inquiry as regards the question of when the cause of action accrued and as to whether or not the claim under contract 1 is contract barred or not. I've trespassed far too long on the court's time. I was proposing to sit down if that's convenient to this court.
Thank you. Does Mr. Turner have any reply?
No, my lady.
Thank you. Thank you very much indeed to everyone for the presentation of this very complex, very difficult case, very interesting case. We reserve our judgments and that's only because it's 25 to 5. But yes, no, after you. And we do understand that there is urgency in this matter, and we will do our best to circulate drafts and finalise our judgments as soon as possible. You'll be very aware of how matters are dealt with in this court, that we will circulate our judgments, be particularly careful in relation to who receives those. You should already have provided the names of those within the circle to receive them. We take that very seriously. And also, as you'll be fully aware, we deal with consequential matters, we hope to at least, on the basis that you will agree them, or alternatively that you will put in some very short written submissions, and we will decide on those submissions. With all of that, thank you, and we look forward to the ultimate outcome in relation to all of these issues when these matters are heard in the Supreme Court. Thank you.
You may.